Yes, this is part 242B Q&A. Okay, question and answers. We're gonna go into some questions because those questions have been asked before. But prior to me going to those questions, I'm gonna tell you something. We are arguing a case this November. Looks like all our cancellation of removal cases come about in November. We argued last year in November, and we are still waiting for the response from the immigration judge. We called to find out why it's taking too long. The office said that the decision is on reserve. Okay. Simply means that the decision is probably yes. They just want to see how to allocate that visa at the end of the fiscal year, right? So that's why it's taking too long. But anyway, so cancellation of removal, really difficult case to win. Sorry. The first question is, wow. Sorry. The first question is, when do I file for 42B? When the case is pending with the court, okay? With the immigration court. I had a client who actually was at the BIA and was filing for 42B at the level of BIA, and the reason he was filing for it like that is because with that notice to appear, the effective notice to appear, remember the decision in Chambers, so people were reopening their cases, trying to argue cancellation of removal based on the effective notice to appear. That's just exceptions, right? But if your case has already been decided at the immigration court, you never talked about it, and then you're right now at BIA trying to file 42B, it's not gonna work, okay? So number 2, physical presence ends with offenses. Remember we talked about how somebody can break the continuous physical presence. Another way that can end and stop and moot the case is with some offenses. Offense that renders somebody inadmissible, deportable, crime of terrorism. Those are some of those offenses that can end physical presence requirement and pretty much disqualify somebody, okay? Who is not qualified? J1, the person who entered with J1 visa, crew members, pretty much it's not gonna work. Let's move on to number 4, hardship of non-qualifying relative. Remember in my previous video I said, well, if you don't have a qualifying relative, you can try with a non-qualifying relative. The way this one is going to play out is this. Matter of Hasina. Remember the law is very clear, right? You gotta have qualifying relative. A person has to be lawful permanent resident or U.S. citizen, period. However, this person here, Hasina's, had qualifying relative. Among qualifying relatives, nobody would suffer her extreme hardship. But she had 2 children who were non-qualifying relatives, like they were undocumented, and those children will suffer extreme and unusual hardship. So the way she went about it, if you read the matter of Arsina, she took the effect on non-qualifying relative and put it on the qualifying relative, pretty much saying that because my non-qualifying relative will suffer extreme and unusual hardship, therefore my qualifying relatives will suffer that as well. Very difficult to put that, just the way I said it before. Number 5 is attention, okay? Can I put myself in removal so that I can claim cancellation of removal? The answer is no. If you do not have a valid claim to file with USCIS, do not put yourself in removal proceedings just because you want to later on claim cancellation of removal. What's going to happen is this: if you file a frivolous asylum claim and you find yourself in removal proceedings and you qualify for cancellation of removal, you're still not going to win cancellation of removal because they're still going to go and look at your entire asylum case as well. If they find it to be frivolous, then the answer is no. You're going to fail on all those. So those are things to watch out, okay? In the meantime, please subscribe, like, share. Don't forget to call for your consultation.